General, is there any chance that the president could say, this is a bad idea, we're going to step back and not do this?
Sure there's a chance. And I think he would regard it as, well, the president would say it, he doesn't say it was his idea. I thought he would say it was a bad idea on directing the general, or his general say it was bad. Once people reach these shores, it's too late. You may recall that during the Mariel boat lift and other operations, the Coast Guard tried to make sure that escaping Cubans did not reach U.S. soil. That was not done out of need or cruel reasons. It was done simply because anytime anybody is within jurisdiction in American port, they automatically, alien or not, acquire essentially the same rights as you and I have. So once they get here, it's too late for doing it.
Next question.
Between the moment this administration was sworn in and Fort Hood, has there been any laxity in the intelligence services? We've heard that there was a lack of communication in the CIA or something. So what do you think?
Well, there's always government, and there's always lack of communication. My own belief is that on the ground operationally, people are gathering intelligence about as efficiently and about as effectively as they did because career people haven't turned over. Whether it's being used as it was before, it's not factual because I'm no longer privy to those things, and if I were, I couldn't talk about it in a forum like this. But the tools are in place. Congress passed amendments to the Foreign Intelligence Surveillance Act, and good for the national criminal evidence. There was an attempt to roll those back when the new Congress took over, which had much larger majorities of the parties, and when the new administration took over. And to withdraw all of those authorities that had been put in place before, and that was beaten back. So far. Yes.
How will they find a jury in New York State? Who's not ready to that?
You know what? Interestingly, no, I'm less worried about that than I am about just about any other aspect of the case. They don't have to find people who have never heard of the case. They don't even really have to find people who don't have an opinion about the case. Somebody would have to be comatose. For the last 10 years or more, and not have to do it. But they do have to find people who can honestly take an oath that regardless of what they fought before, they will decide the case based only on what they see in the courtroom. That's not a hard principle to understand. And people apply it. People applied it in the case that I tried. Everybody has heard of the 1993 bombing of the World Trade Center. As it happens, I committed a mistake, an error that favored the defendants during the charge. Two of them were acquitted on some counts as a result of that mistake, because the jury followed faithfully the charge, notwithstanding whatever views they had about the overall will of the defendant. I think you can find people who do that. It ain't gonna be easy, but that part of it worries me a whole lot less. Obviously, they would have to be picked anonymously. They would, as the jury was in my case, have to be picked up at locations distant from the courthouse, brought to the courthouse by the marshals and dropped off at night. And when you stop and think about it,
Would have to be protected.
pardon?
They would have to be protected.
They would have to be protected, but when you stop and think about it, those people aren't going to come down from Mars. Each of them will have at least one good friend who may very well know that they're on the jury. And whether or not they do, each of them will call the jury. The entire will amend themselves. You only have to just have to call the jury. And then will somehow suddenly not be available for the duration of the trial. It would not be hard for somebody to conclude, based on that they were on that jury, particularly if they came to court slow, as a public trial. I will tell you that notwithstanding the anonymous juries, two of the jurors in my case found reporters on their doorsteps when they got home, and they were terrified.
I'm going to abuse my office here and then take advantage of the fact that we are off the record tonight. I'm going to ask a question that bothers me a lot. I want to
every point of view, a relatively common theory. The reason this trial is occurring in New York is that it is asserted it means to try, push, and shame the public opinion.
I hope and like to think, I mean,
I agree with you.
I'd like to think that that's not true. The mechanism, let me advance the facts that are consistent with it, and then hopefully try to knock it back a little bit. You may recall that some months ago, confidential memoranda drafted in the Office of Legal Counsel of the Justice Department relating to harsh interrogation methods and why they did not constitute torture were released. And people in the intelligence community opposed that because they felt that, first of all, it was illegal, and secondly, it would reveal to people on the outside what the limits were of what they could be subjected to and what the legal theories were for upholding those limits, and essentially provide them with yet an additional training manual, which they already have, the Army Field Manual, which now sets the limits. That's available on the internet. Without the Army Field Manual, they would now have this additionally to training. And what was rumored was that it was hoped by people who were responsible for the release that the reaction would be such mortification by the American people that they would rise up against those who were responsible for putting practices like that in place, even as the 3 people who were awarded with it, and the few others who were subject to other harsh interrogation methods, that there would be such revulsion that the people in the prior administration would be harshly criticized and perhaps even shot. The reaction, by and large, was, forget who the reaction was Peggy Lee. Is that all there is? The reaction was fairly tame because the build-up in advance had been so substantial, the safeguards were so rigorous, and the reasoning was what it was, that people sort of couldn't believe it all was over. A trial like this, of course, would allow almost only one person on trial, was in fact ordered, and that's Khalid Sheikh Mohammed, to talk about what it's like, somehow found a way to make that relevant, and have to remove the move all over it. I was invited here to speak to the public. I'm a Republican myself, but I can't believe that any public servant, be it Democrat, be it Republican, would pervert the system simply for the purpose of doing that. I just can't believe it.
That's reassuring. Question?
Yes, Judge. In your opinion, does this set any, the trial in New York, does it set any sort of precedent that we have to do civil trials for enemy combatants?
I hope it doesn't set a precedent. You just recall that at the same time that it was announced that these people would be brought to New York, it was also announced that another group, Mukaseys and a couple of others, who were charged with planning the attack on the Cole, would be tried before military commission. Now, it seems to me if the military commission is good enough for them, it would be good enough for these folks. There were certain criteria advanced for choosing one form over another. And one criterion, for example, was that civilians were attacked on 9/11. You know what? Last I looked, the Pentagon was a military target. Last I looked, the plane that was headed for Play Crafts in Shanksville, Pennsylvania, was actually headed to the Capitol. It was intended to decapitate the United States government. That's a military strike. So I don't think the distinction holds up. But as far as whether it constitutes a precedent, I don't think so. I hope not. But certainly I don't think it constitutes a legal enforcement precedent. It's a matter of policy as to where people get brought to be tried.